Since we're located in New York, we want to make sure that we go over the new COVID-19 sick leave law in New York State. This became effective March 18th, 2020, and is specifically related to the COVID-19 virus. This law breaks down requirements into 4 different categories: small private employers, medium private employers, large private employers, and public employers. And the requirements under each will vary depending on the size of the employer. For small employers, small private employers, if they have less than 10 employees as of January 1st, 2020, income less than $1 million based on the previous year's tax return. If that's the case and they qualify as a small private employer, then employees are entitled to unpaid sick leave if they are under a precautionary or mandatory order of quarantine or isolation, and that unpaid sick leave will run through the period of quarantine or isolation. For medium private employers, this would be an employer with less than 10 employees that has an overall income of $1 million based on last year's return, or an employer that has between 11 and 99 employees. So both of those categories fall into the medium private employers. For those employers, they must provide 5 days of paid sick leave to any individual that is subject to a precautionary or mandatory order of quarantine or isolation. And employees will also be entitled to unpaid leave through the remainder of the quarantine or isolation period if they work for a medium private employer. Then we have the group categorized as large private employers, and this is an employer with 100 or more employees. These employers are required to provide 14 days of paid leave to eligible employees. In addition, the employee is entitled to unpaid leave through the remainder of the order of quarantine or isolation. For public employers, which includes all state and local government entities, these employers must provide 14 days of paid sick leave to eligible employees, and that paid leave must be paid out at the employee's regular rate of pay. For whatever reason, this is the only category where the governor actually set forth the definition of the amount of pay that the employees are entitled to, and that's at their regular rate of pay. So then there's some additional New York State quarantine benefits. After any employer paid leave, if the employee is still under an order of quarantine or isolation, then the employee may be eligible for enhanced disability benefit payments or paid family leave benefits that will last through the remainder of the quarantine or isolation period. For whatever reason, under the new law, public employers and large employers are not required to, employees that work for public employers or large employers are, this law doesn't apply to. These extra quarantine benefits doesn't apply to. It's unknown if this will be modified moving forward. Normally, New York State has a 5-day waiting period to receive disability benefits. That 5-day waiting period has been waived for a disability related to quarantine under COVID-19. If an employee is eligible for benefits under the quarantine leave, then they are eligible under the paid family leave benefits. They're eligible for a maximum of $840.70 per week, and are also eligible for disability benefits under New York State, which is a maximum of $2,043.92. These employees are eligible for both sets of compensation simultaneously. this is kind of a significant amount that the employees are entitled to, but that is what the law requires. Scott has done this wonderful calculation for us and has determined that if an employee makes $150,000 per year, then that employee is entitled to their full compensation when collecting both that paid family leave and disability benefit leave over the course of that quarantine. They would get the maximum amount entitled under paid family leave, and then also the amount under disability leave to bring them up to full compensation for the period of leave. However, if you have an employee that is making less than $1,400 per week, they wouldn't receive their full compensation, and that's because they wouldn't be eligible for the full maximum benefit amount under paid family leave, and then they would be entitled to the disability leave, which would not reimburse them for their full their typical regular wage, but they certainly would get a significant amount of compensation during that quarantine period.
Julie, I just want to jump in real quick on that because that is what we think the statute actually says. It may be that that's not what the state intended, and there will be regulations issued at some point by various state agencies, so they may clarify that. But yet it is creating this odd scenario that possibly what the law says is if you make less than basically $1,400 a week, then you wouldn't max out on paid family leave, and under one reading of the law, the disability benefit wouldn't fully make up for the difference. But I don't want to get too carried away on that right now until we have the regulations, although I recognize that this is currently in place, so this is a real question facing people today. But we can't be 100% sure about the answer, unfortunately, because it seems to be unclear and probably inconsistent. The language probably inconsistent with what we think they really meant.
Thank you for that clarification. And I think I'm going to turn it over to you to address the federal leave. Oh, I lied. I got one more slide. So exceptions to the New York State quarantine leave. There are a few exceptions. There are no leave or benefits that employees are entitled to. An employee that is asymptomatic or that has not yet been diagnosed with COVID-19 and who has the ability to physically work through remote access or any other means, depending on if they're an essential business, they will not be entitled to leave benefits under the quarantine leave. And they have to meet both criteria. There are also no benefits paid to employees who have knowingly traveled for personal reasons to a country or area that has been designated by the CDC as a level 2 or level 3 threat. Employees that fall into this category will still be entitled to the unpaid leave under the quarantine or isolation order, but they will not be compensated during that period of leave.